get started up. Thank you all. So please join me in welcoming our book talk speaker, Dylan Pennegroth. It's a pleasure to have him here. He's going to be telling us about his new book, Before the Movement, The Hidden History of Black Civil Rights, which just recently came out with Norton, or I guess some subset of Norton. I didn't quite understand that. Yeah, I think of it as Norton. I don't know. He's a professor of law and history over at UC Berkeley and currently serving as Associate Dean of the program in Jurisprudence and Social Policy at Berkeley Law. He specializes in African American history and legal history. His first book, The Claims of Kinfolk, African American Property and Community in the 19th Century South, was published by University of North Carolina Press. It won the Civil War and Reconstruction Book Award from the Organization of American Historians. His articles have appeared widely, including in University of Pennsylvania Law Review, Journal of American History, and the American Historical Review. And he's held fellowships from a bunch of fancy places, including the National Endowment for the Humanities, the National Science Foundation, our own Stanford Humanities Center, where I had the pleasure of overlapping with Dylan. We were young, yes, not that long ago, and the MacArthur Foundation. So thank you.
Thank you. Well, thank you very much. Thank you. I want to just say also thank you to Dean Jenny Martinez, the Stanford Law School, the organizers, Doris, Giselle, and also to Rabia and Karen and Amalia, who have patiently listened to me talk about this stuff that you're about to hear for a little while. I won't say how long. It's really exciting. It's a privilege to be able to be done with this book project and to be able to share some of what I learned along the way with you today. So at its broadest, this book that I've written, Before the Movement, is about how Black people used law and thought about law and talked about law from about the 1830s through the 1970s. And I'm going to tell this story today partly through the eyes of some of my own relatives. And what I'm going to try and do is I want to try and persuade you that looking at a history of Black legal lives can open up new ways of seeing areas of legal doctrine and legal theory in the law school curriculum. That's the first thing I want to try and do. But then I want to take this history of Black legal lives and use it to challenge some of the ways that we as historians and law scholars have come to talk about civil rights. It's this key term that I'm going to talk about from time to time, civil rights, and how it might change the way we look at African American history more generally. So, how do I do this? I get a slide. Is this like a touch screen that I touch here?
Somebody more competent than I will make it worse.
I should have thought of this a minute ago. I know we're short on time. I'm keeping an eye on that clock. The space bar? Okay. End of slide.
No, your stuff's not.
Oh, okay. So I need to boot it up.
Yeah.
Oh, that's
Tired.
thank you. I can walk around. Yeah, thank you. Hey, it works. Like I said, I should have thought of this a few minutes ago. All right, so here I think is a familiar kind of image. This, I think, is the story of civil rights that most of us know pretty well, right? And it goes like this. So you have this segregated legal system. It's dominated by racist state and local officials, and they refuse to recognize not only Black people's civil rights, but their basic human dignity, right? There's this humiliation going on here. But also, of course, sometimes their lives. So on this story, law is this hostile, fearsome power. It's something that you want to avoid whenever it's possible. It's full of unknowable secrets. It's often deadly. And then, according to this story, a few lawyers, brave lawyers, venture south, and they're bent on changing the law. And so these lawyers confront the system with a series of carefully planned strategic lawsuits, and also with the powerful symbolism of a Black lawyer in a white courthouse. And so then ordinary African Americans, their sense of possibility has been awakened by cases like Brown versus Board of Education in Topeka, and by other Supreme Court victories. galvanized by racial justice activists, ordinary people coalesce into a mass movement that essentially demands the federal government force those racist state and local officials, the people inside this building, recognize Black people as free, full members of American society. This, I think, is the master narrative of civil rights. And it is a powerful one, not least because it refuses to concede to right-wing reactionaries the power to say what freedom is. It's also powerful, I think, because history, of course, is not just about the past. James Baldwin, at the height of the civil rights movement, wrote, "History is literally present in all that we do. We carry it within us." And so the choices that we historians make, what to write about, what counts as evidence, and how do we interpret that evidence, these decisions are inevitably shaped by the world around us. African American history, of course, is no different. In its modern form, it grew directly out of the civil rights movement itself. So activists in the 1960s, people like Vincent Harding, they created Black history units that they then taught in the Mississippi Freedom Schools they had set up. At colleges, there was a Black student movement that demanded Black history courses, demanded faculty to teach those courses. They demanded a wholesale rethinking of what our country's past is and how it should be taught. And so many leading Black historians came into this field profoundly shaped by their experiences as activists in the 1960s. And some of them actually explicitly said that their scholarship was a continuation of the struggle for Black freedom. Today, I think as many of us know, historians are still committed to the idea of scholarship as struggle, but many of them in this field, civil rights history, they're debating about what that struggle was and what lessons it holds for today. So if you think about the first generation of historians of civil rights, they're looking from the top down, from the perspective of great leaders like Martin Luther King, famous lawyers like Thurgood Marshall, statesmen like Lyndon Johnson, and of course the liberal justices of the Supreme Court. In more recent years, probably the last 30, 40 years, I'd say, there's been a grassroots approach that's transformed our understanding of the movement by rethinking it from the perspective of local people. That term crops up again and again, local people, ordinary people, grassroots people. And so people writing in that vein have often tended to take a long view of the era of mass protests that we commonly call the movement. That is, the dozen or so years between 1954's Brown decision and the mid to late congressional acts, the Civil Rights Act of '64 and '68, and the Voting Rights Act of 1965. So this long civil rights movement narrative, popularized by Jacqueline Hall back earlier in this century, it looks back toward the 1930s, and then it looks forward to the 1980s, and the goal is to reveal a much bigger struggle, a struggle for full citizenship, economic justice, and true grassroots democracy. So on this view, the movement activists basically realized that civil rights are not enough. Real freedom, these long movement scholars argue, real freedom, the activists realized, meant changing the underlying structures that kept most Black people poor, politically weak, undereducated, and abused by the police. It meant transforming American democracy itself. What hasn't been rethought, I think, is this fundamental moral drama of the movement, in which civil rights and Black history more broadly are being framed as an unfinished freedom struggle, a battle against the forces of plunder, as Ta-Nehisi Coates puts it, a journey from humiliation to dignity, from second-class citizenship to full citizenship, from Black fear in the face of white lawlessness to Black people defiantly asserting their rights under the law. And I think that moral vision is gleaming still brightly today as police killings continue mercilessly and as Republican politicians enact policies knowingly that systematically hurt Black people. In other words, movement-centered scholarship is as urgent and necessary today as it was in the 1960s. But the notion of Black history as a freedom struggle has also cost us some things. For one thing, it's helped make Black history almost synonymous with the history of race relations. It's as if black people's lives only matter when there's a white person somewhere in the picture. It has also tended to lay a moral burden on African American history that few other scholarly fields have to carry. It urges us to judge our ancestors according to how well they advanced the freedom struggle. It's also infused a subtle romanticism into some parts of African American history, where black people play the role of humble folk heroes overcoming adversity against the odds, or fugitives defined by a common history of dispossession and a yearning for freedom. But I think most of all, it's shrunk our vision of black life itself down to the few areas where federal law and social movements made a difference. So if you think about it, you can find shelves full of books about the struggle for the right to vote, to open up the workplace, the schools, the military, and to challenge a violently racist criminal justice system. But surely black people care just as much about things like our own Lawrence Friedman has written about, like marriage and divorce, old age care, property owning, and running churches and businesses. But these don't fit into a story of freedom. In a sense, I think that historians have often echoed the racial justice activists of the 50s and 60s, whose courthouse showdowns with hostile white officials have become canonized in movies like Selma and Just Mercy. We've tended to assume that because African Americans were afraid to go to the courthouse to vote, as one black farm worker wrote in a letter to the NAACP, we've assumed that they were afraid to go to the courthouse for anything else. In other words, it's been easier, I think, to imagine black people fighting for freedom or justice or something like full citizenship than it's been to imagine them arguing over alimony or a deed of trust. So in the freedom struggle story, black people are seen as ordinary and heroic precisely because they knew so little about law. But if that is so, then why is it that when a mass movement against racial injustice finally took hold in the 1950s, why is it that so many black people put their faith in law at all? Civil rights history has left black people disconnected from our own legal common sense, the way that we actually think about and use law in our daily lives. It's made it harder to see black people as people in full. African Americans use civil rights all the time. They just weren't the ones that we today think of as civil rights. They weren't about protection from discrimination or subordination on the basis of race, sex, or other protected categories. Instead, they were what one of the framers of the 14th Amendment called the ordinary rights of a free man. The basic rights of contract, property, and standing that Congress wrote into America's first national civil rights law, the Civil Rights Act of 1866. And during the grim decades of Jim Crow, these were the rights that people exercised, and they did it not just in court, but out in their daily lives, although they rarely had any reason to call them civil rights. So when my great-great-aunt Annie Holcomb paid my mother's burial insurance policy each week on her doorstep, when she and my great-great-uncle Thomas Holcomb sold land to Midway Baptist Church, when they wrote down instructions about how they wanted to be buried and where they wanted to be buried on that very same land, every time they did something that a court could protect, they were doing civil rights. They were exercising freedom, making it mean something more than the negation of slavery, the end of whips and chains. Civil rights were rights of everyday use. Okay, so now big picture framing, I think, is part of the reason why this history has remained kind of hidden behind a veil. But there's an even more basic reason that it's been hidden, and that's because of an institutional practice. And that is that legal documents typically do not identify people by race. Not in the keyword searchable appellate reports that you can find on Westlaw and Lexis, and not even, this is surprising, in local courts in Mississippi. This is kind of weird. Like, this is Mississippi after all. This is the place where, you saw a few slides ago, the water fountains were segregated, right? So why is it that these old records, during an era where the courts, these very same courts, are charged with enforcing segregation in so many other areas of law, why is it that these records are not consistently or even rarely marked white in color? I can come back later with a partial explanation of why and why it matters. But I just want to say for now that my most urgent project, as I set out on this project about years ago, it was kind of practical. I wanted to write a book about Black history, and I couldn't tell who was Black. So there I was, and I had to figure out what to do. So what I did is I hopped in my rental car, and I started driving, and I would spend a week or two at a time visiting courthouses, in county courthouses. I think many of us in this room have probably done a version of this same thing. I'm kind of preaching to the choir, you know what I'm talking about. And so I would take pictures along the way. Many of you probably have pictures like this one that you took. And so I'd show up at the office of the circuit clerk for that county. I would ask to go in the back room. Most of the time they said yes, actually. And so when I gotten back, I would start pulling down dockets at 10-year intervals. So you got these big cloth-bound dockets. You got the names, you saw versions of this before, and I would copy down the names of a subset of the cases for that year. And then I had a succession of really talented graduate students, and together we would look up each one of the names using Ancestry.com, right? The part that's online, not this part, right? So this is how we figured out that Marinda Orr was Black, okay? So of course, this is not a foolproof method. No method is foolproof, of course, when you're dealing with records that are organized like this. Me and the clerk, we were actually, he told me to do it. We were climbing on top of we were standing on these books, because it's the only way to get to the things that we needed back there. Okay, so you have this, this procedure that's imperfect, and gradually we started to see a picture of when, where, and why Black people used the courts. And so by the end, we had looked up more than 14,000 civil cases from 24 courthouses in 5 states in the District of Columbia. And we identified more than 1,500 of these involved Black people. So, race ducks in and out of Westlaw, and it's pretty much invisible in the county court dockets. This is how we made it visible. In fact, we found more cases involving Black people during the Jim Crow era than during Reconstruction. The percentage actually goes up over time. So they go from filing an average of 8% of the civil suits in 1872. Again, this is a slice of a sample. It rises to 11% in 1892, 17% in 1902, and then it levels off for the next 20 years. The other interesting thing is that they're less likely to sue than white people, but not drastically less. So relative to their share of the population in a given county, Black people were plaintiffs in 12% of the civil suits that I sampled in certain Mississippi counties for 1872. And in that year, 62% of those counties' populations were Black, right? So 12%, 62%. And then by 1902, this is the time when 72% of the county's population was Black. They filed 36% of the civil suits. So they're underrepresented, but not grievously so. In fact, sometimes they were overrepresented, especially in counties where they're not a very high percentage of the population. So what do they do there? They're using the courts for all kinds of things, a lot like white people did. So they're suing for divorce. They're suing over insurance payouts, car accidents, railroad accidents, workplace accidents, farms, unpaid rent, and personal property. They're going to court to swear out writs, to get satisfaction from white neighbors who assaulted them, from town officials who damaged their property, and sometimes to hush up family matters. They also used private law in more routine adversarial ways. So, for example, they sold easements on their land. They made wills and got them probated. They got cars towed off of their property. They sorted out home building contracts, drunk driving charges, and landlord-tenant disputes. And of course, they bought, sold, and gifted land. Now, I want to be clear that, of course, this was not a level playing field. Think about the baseline rules of property contract and civil procedure. They silently favored the haves over the have-nots, the repeat players over the one-shotters. So if you think about one Alabama tenant farmer, Nate Shaw, he puts it this way: the colored man wasn't educated to the laws for his use. It was a great dark secret to him. And yet what's fascinating is that even as white local officials cut them off from formal schooling, farmers like Shaw took pride in having what he called goat sense, which I think is kind of a colloquial way of saying the common sense that God gave a goat, the rough and ready knowledge of law that most grown-ups possessed to some varying degrees. So for example, Shaw knew that each party to a joint promissory note is liable for the other's debt. He knew that a husband's mortgage did not cover household goods unless his wife signed the paper too. And he knew that a renter at the end of his lease had, and I'll quote here, this is from him, the right and the privilege to take anything that ain't tied down. End quote. And so that goat sense gets refined through daily experience, and it gets discussed in churches, schools, and in Black-owned newspapers. Now again, I want to be very clear. With very few exceptions, Black people's legal activity did not challenge white supremacy. It didn't challenge it in any substantive way, and it didn't challenge it in any symbolic way. So Black people routinely have contract dealings with white people, but most of their lawsuits are against other Black people. Only 8% of the cases in my Jim Crow part of the sample cross the color line. They don't challenge white supremacy in any symbolic way because, as I've been showing you, there's nothing surprising about seeing a Black person in a local courthouse, even in Mississippi. And yet African Americans clearly cared about private law. And if you look at Black newspapers, you can see that even in the worst years of segregation, prominent African Americans are expressing a wary faith in contract and property as levers to, quote unquote, uplift the race. So the AME Church Review predicted, quote, when we own railroad stock, we can have the Jim Crow car taken from the road. Just think about that. Like, this is a hope that is not realized, but they're thinking about it. A leading minister put it this way, and here I hear my uncle's voice talking to me even now. Buy land, be a freeholder, and no power on earth can keep you down. In short, the obstacles to Black people using their civil rights during Jim Crow were not always as simple as the white and colored signs that were going up over the water fountains. Now, of course, the meaning of civil rights rested in the hands of local officials, like these dudes. In the 1890s, of course, when the white supremacists bulldozed their way back into power across the South, they fired all the low-level Black office holders. So what that means is that this is a world where the law is not only being written by white people, but it's being enforced and administered by white people. Sheriffs, justices of the peace, clerks, special masters, notaries, and like guys hanging out on their lunch hour. So when I walked into the courthouse, and this is important, thinking about, I'm part of I think like a mini boomlet of people who are working with local court records. Some of us are here, others aren't, like Laura Edwards, Martha Jones. We're all part of this mini boomlet. But I want to emphasize that we are all walking in the footsteps of an earlier generation of Black historians, people who negotiated with the gatekeepers of official records in the unfathomably harsher environment of the 1930s and 40s. And what these earlier Black historians wanted to demonstrate was that in spite of their second-class citizenship, free Negroes, that's what they called them, free Negroes and their descendants had made a record of achievement. A record of achievement in education, land ownership, and trade. A record that ought to entitle them to first-class citizenship, right? So you see these fundamental civil rights, libertarian civil rights, ought to entitle you to these broader civil rights that are coming to dominate the minds of thinkers by the 1930s and 40s. By the 1960s, Southern County courthouses, as you know, have become a stage for protest. So just as Rosa Parks in 1955 turned a bus into what Robin Kelly calls a moving theater of injustice, voting rights activists in the 1960s turned county courthouses into a made-for-television drama in which ordinary Black people suddenly seem to shake off centuries of fear. They start to confront racist white sheriffs and county clerks and start demanding their rights. So you think about the notorious police attack at the Edmund Pettus Bridge, where SNCC chairman and future Congressman John Lewis and other activists had their skulls cracked open. That happened at the start of a march that was headed to the Montgomery County Courthouse. So over and over again, in one county seat after another, black marchers kneeled to pray on the courthouse steps as white cops glowered down on them from out in front of the tall, heavy double doors. And then photographers captured the moment when the first black registrants stood in the inner sanctum. The caption to this actually says, he's this very gracious, it's very calm. But John Dittmer, says that when the television camera went away, he just turned into an ogre. He's just like doing everything he could to make everybody feel unwelcome here. So the activists recast black people's experiences with property and contract, and indeed sometimes their own experiences with property and contract, in nostalgic, almost anti-legalist terms. So they contend, for example, that this white-dominated legal system was eroding black cultural values of independence, dignity, and community. Now, I want to be clear, the activist views on this were complex. A number of the most influential and dedicated activists of the 1950s, 60s, and 70s, people like Medgar Evers, Ralph Abernathy, Rosa Parks, Malcolm X, Ella Baker, Martin Luther King Jr., and Shirley Sherrod, they all came from landowning black Southern families. And in some settings, they described property and contract just the way their parents' generation did, as rights of everyday use, or as privileges of status within an association. So Abernathy recalls in his 1989 autobiography, and I'll quote, "My father always said that land would be the means by which we would rise in the world." And he goes on to explain that his father had a reputation as the owner of 500 acres of prime farmland. He had a reputation as a man with good credit who paid his bills, and Abernathy believed that this reputation gave his father standing in the community and a kind of fragile equality based on mutual respect and a certain standoffishness. Shirley Sherrod, for her part, she remembered that her extended family owned hundreds of acres in Baker County, Georgia, and she remembered that hired laborers and tenants did most of the work. Ella Baker described her grandfather's purchase of his former master's plantation as what she calls the seedling of her family's local prominence in ministry and politics. And she said that it taught her her first lessons in the power of community. And moreover, activists like Baker and Sherrod and Abernathy were drawing on the rights of everyday use as they worked within the larger freedom struggle. But in doing so, they began to talk differently about those rights and about black legal rights. So as activists began to gather signatures for the fateful school petition that would launch the case that would eventually become Brown v. Board of Education, they decided to approach landowners first. And as school petitions gave way to a mass movement, black landowners let out-of-town activists turn their spare bedrooms into offices and their farms into meeting grounds. They signed bonds against their farms to bail civil rights workers out of jail, and they fed the workers from their restaurants and often worked hard on voter registrations drives. So that famous 1965 march from Selma to Montgomery, it might never have happened if it weren't for black landowners along Highway 80 who gave the marchers permission to camp on their land. So the activists knew that the black landowners were sticking their necks out, and they're wincing as the landowners lose their jobs, cotton crops, and their mortgages. And they're fuming as key local organizers are trying in vain to protect their own properties from spurious slander judgments. And they realize how helpless they are to protect local activist landowners. And they're profoundly aware that they are witnessing history. And so the out-of-town activists try to make sense of what they're seeing. And they find their explanation in culture. The activists figured that some black people were already primed to get involved in the movement because they had grown up in landowning families, relatively protected from white racism and unafraid of it. So in Madison County, Mississippi, core activists were awestruck by C.O. Chin, a restaurateur and landowner, locally known as, quote, the type of person that didn't take shit from anyone. In Holmes County, there was Hartman Turnbow, who in 1963 fired back at white terrorists and then warned, quote, the sheriff and everybody else that anybody he caught on his land after dark was going to get lit up like a Christmas tree. So the activists are hugely impressed by this kind of bravery, and they came to believe that landowning instilled in black farmers a certain independence that sharecroppers lacked. They began to think that sharecroppers suffer from what they call the plantation mentality, which they describe as an ingrained sense of helplessness and dependence on whites. Now, of course, in the mid-20th century, these cultural theories are everywhere. Think about the Moynihan Report, about the Negro family in urban ghettos seeding a culture of poverty. Or think about the Supreme Court's warnings about how segregation is implanting harms of segregation on the hearts and minds of Negro children. And so movement activists, especially those who did not grow up in the rural South, they passed their cultural theory of black landowning, along with their open admiration for plain-spoken local people, they passed this on to scholars. The cultural theory explained and justified what they were doing in the South. But what the cultural theory left out was law. The cultural explanation tended to treat legal relations like shared tenancy or land ownership as talismans that somehow produced lifelong patterns of behavior. It overlooked copious evidence that black tenant farmers viewed a tenancy contract as, well, a contract. The local people the civil rights workers were trying to teach were actually quite familiar with legal rules and concepts. And it was a familiarity that was born as much from legal relations among African Americans as from fights against white supremacy. Many of the youthful activists, for example, lionized Hartman Turnbow. Remember the guy who was going to light up the sheriff like a Christmas tree? They lionized him for his plain-spoken defiance of white authority. But when you think about what Turnbow himself is talking about, he is actually emphasizing an example of a black landowner manipulating property law to defy black authority. That is, leaders of a certain church who wouldn't let him preach the gospel of voter registration. Even Ella Baker, who's a revered figure within SNCC and one who, unlike some of the main field workers, actually did come from the rural South, even she encouraged this anti-legalist cultural explanation. So when Baker told oral historians that her philosophy of community organizing grew out of the cooperative, sharing spirit of her Southern upbringing, that is, out of a deep sense of community that had suddenly somehow gotten lost when black people migrated to the cities, historians then relied on those interviews to assert that her grandparents never regarded the land as private property. And in doing so, they were downplaying the tenancies in common, contracts, mortgages, donative gifts, and associated charters that by Baker's own account, her parents and neighbors had actually relied on. So when Shirley Sherrod, another SNCC field worker, told her story for an oral history project in 1994, she insisted that the laborers who worked her parents' farm were like family. It's a really interesting concept, just like family. Of course, she's ignoring the enormous power differential between them. In fact, both Baker and Sherrod glossed over the inherent contradictions of a cooperative community where one family owned and controlled most of the land. In short, black Southerners' decisions during the 60s campaigns were shaped by their working knowledge of state-based private law. This is some of the roots of the civil rights movement. This is why it worked. And yet movement activists then interpret those behaviors as part of a Southern way of life, one that they believed had kept black Southerners alienated from law, kept them from knowing anything about law, and afraid to approach the courthouse. And so then in their memoirs and oral interviews, activists created this documentary record of what local people had said and done in the 1960s. And they sometimes underlined the grassrootedness of this freedom struggle with earthy, profane language, just as many activists had taken to wearing denim clothes on protest marches. So, speaking of one landowning family, SNCC's Bob Zellner marveled, quote, "They simply didn't take no shit." Another SNCC field worker recalled that, quote, "You didn't fuck with C.O. Chin because he would kick your natural ass," end quote. Now, to be clear, there were some SNCC activists who were fully aware of what they called local peopleitis, the romanticization of poor Mississippians. And they understood that sometimes this could be used as an excuse for their own organization's disorganization and inaction. And some of the activists did recognize that local people understood basic legal terms and principles. And yet again and again, the movement lifted civil rights up from the house porch and the county courthouse into the universal values of freedom, justice, and dignity, and then returned them, transfigured as moral arguments. Something got lost in that transfiguration, and that is the long, rich history of Black people's experiences with law. So by the 1960s, movement activists were urging what they called a grassroots approach to help what they described as the millions of exploited, disfranchised, and degraded Negroes of the Black Belt, to understand the meaning of first-class citizenship, to help them gain enough confidence in themselves to seek and assert their rights. In 1965, the Mississippi Freedom Democratic Party unwittingly relied on tropes of Black ignorance to describe 3 delegates who had unsuccessfully challenged the white Mississippi Democrats' right to represent the state at the Democratic National Convention. Much as Union officers in 1865 had thought that they needed to teach newly freed slaves about property rights, much as white Southern lawyers had tried to win cases by presenting their clients as quote-unquote ignorant Negroes, and much as white liberals at that very moment were describing a woman named Ora Lee Williams as uneducated and helpless, the MFDP asserted, quote, Mrs. Hamer, Mrs. Devine, and Mrs. Gray do not know much about legal things. And that alleged homespun innocence about legal things helped validate the group's agenda. It affirmed their belief that they were faithfully representing the wishes of the South's poor Black folk. The 3 women, they said, do not know much about legal things, but they know what we want. And that, as Ella Baker put it, was much bigger than a hamburger. They wanted the right to vote, the right to use public facilities, to have jobs and decent schools, as well as a larger freedom, a freedom of the human spirit. But of course, Black people had known about legal things for a very long time, and they were still highly active in the courts at that time. And so I think activists bequeathed to historians 3 deeply flawed assumptions. First, that common law civil rights under state law and the local courts that judged those rights had been a closed book to Black people before the modern freedom struggle. Second, that those were not civil rights. And third, that they were essentially irrelevant compared with protection from discrimination or subordination as defined by Congress and the Supreme Court, much less compared to the broader human freedoms that activists now sought. As historians in the 1980s turned away from top-down approaches to the history of civil rights, they relied heavily on accounts about, and sometimes by, movement activists that positioned local people at the center of the freedom struggle, while explaining those people's actions in cultural, almost anti-legalist terms. The first generation of civil rights activists had told a story of simple justice won at the Supreme Court. Those who rewrote that story from the bottom up wound up limiting what counted as civil rights, or even veered away from law altogether. Both versions of the freedom struggle story shrank what counted as civil rights and distorted what Black people actually thought about law and did with law. And because so much of what Black people actually thought and did with law had to do with other Black people, it also narrowed what counted as Black history. The sacralization of civil rights made it hard to see Black people's presence in the very areas of law that were at the heart of the law school curriculum. After all, the flagship 1L courses, then as now, included contracts, property, and civil procedure, essentially what the Republicans had written into the Civil Rights of 1866 as the rights of free men. So in the 1970s, under intense pressure from students, most of the top law schools, including Stanford, were introducing new courses on Blacks and the law, civil rights, poverty and minority law, legal problems of the poor, and consumer credit. And first-year courses were also starting to cover various forms of inequality. And here they're incorporating insights from the growing field of law and economics, and also from what is now known as the law and society movement. But the law school curriculum and the academic movements that were reshaping it still stumbled when it came to race. So the curriculum tended to equate civil rights with minorities, And in doing that, they implied that civil rights and, that contract and property law were not civil rights. And then well-meaning faculty colleagues underlined that conceptual divide when they told newly urged minority law professors, quote, don't get too caught up in civil rights or other ethnic subjects, right? They think they're giving sort of helpful advice, but they're underscoring this divide. And then, of course, so did white law students who famously here at Stanford Law School refused to talk about race in the core courses where the supposed race was extraneous, as well as in the constitutional law courses. By treating civil rights as a special minority-focused body of law, the law schools veiled what cases brought by Black people had contributed to core areas like contract law. They implied that Black people encountered law meaningfully only in criminal justice, voting, the workplace, schools, and public accommodations. That is, only in cases about race. This is understandable because, of course, the leading cases of the 60s and 70s made it seem as though contract law had nothing to do with either minorities or civil rights. But the students couldn't have known that, and neither could their professors. The 1972 edition of Fuller and Eisenberg's Basic Contract Law featured several cases involving African Americans. Taft v. Hyatt, which the casebook used to teach offer and acceptance. In that case, the person described as, quote, a member of a Masonic lodge was actually a member of a colored Masonic lodge, and that lodge was trying to protect him from a lynch mob. On page 255, in the section on past consideration, there was Harrington versus Taylor. Here, the plaintiff sued on an oral promise to pay damages after she had injured her hand, saving the defendant from being decapitated by his wife. It turns out that all of the parties in that case were Black. And then there was Ricketts versus Pennsylvania Railroad, where Judge Jerome Frank used a railroad waiter's attempt to avoid an accident release as an opportunity for a grand comparison between the will theory and the objective theory of contract. I ordered Sidney George Ricketts' pension file from the National Archives, and he was Black too. So in their editing and in their case selection, the case books inadvertently muffled the role that Black litigants and racial ideas in the legacy of emancipation had played in the development of contract law. In fact, what got reprinted in the case books was only the last in a string of decisions about whether and how to talk about race. And these decisions got made at every stage of the legal process by litigants and lawyers, trial and appellate judges, casebook and restatement authors. Similar to the way that some colored people were allowed to pass as white, colored cases got passed silently into the heart of contract law. They got passed in when legal professionals elided the fact that a litigant was Black, and when they turned slavery into an abstraction detached from race. The result was to make civil rights and contract seem like completely separate categories of law, darkening one, whitening the other, and impoverishing both. And that encouraged white students to think of race as something tangential to real contract law. Whether they made these decisions out of embarrassment or out of a desire to modernize law teaching, the law professors, casebooks, and classroom choices treated Black students as guests to a white limestone cathedral built by white men. So in the fall of 1972, when those students opened their contracts casebooks, the only case that even hinted that the people involved were Black was in the section on unconscionability, Williams versus Walker Thomas Furniture Company. In 1866, contract and property had been considered the very heart of civil rights. In 1970, James Allen McPherson, a Black Harvard law student, wrote in the Atlantic Monthly that for Black law students, learning about civil procedure and contracts and esoteric 13th century property law meant betraying their true interests, which were in civil rights and civil liberties. And that tension posed a problem of fidelities that would haunt their careers. Like many others, McPherson decided not to be a lawyer. Now, I want to be clear. Property and contract were tools, not saviors. And in that realm, To quote the sociologist Mark Galander, the haves usually come out ahead. Or, as Billie Holiday put it, them that's got shall get, and them that's not shall lose. So this is not a lament for the path not taken. What I am trying to do is to replant a familiar story in the soil where it first grew. But how? Some historians contend that mass incarceration is the new Jim Crow. They contend that murderous policemen are the direct descendants of the slave patrollers and the lynchers. Predatory lenders are plundering Black Chicagoans just as landlords plundered their grandparents in Mississippi. Republicans' attacks on democracy are downstream from the feverish pro-slavery politicians of the 1850s. Or to put it as Jamaica Brown Nagin has put it, Occupy Wall Street and the movement for Black Lives are part of a long resistance, one that goes back to the abolitionist, suffrage, and progressive movements. It is right and good to make these connections. But there is also so much to learn when we open up our vision of Black legal lives beyond the Constitution and the criminal justice system. If we want to understand why only 17% of Black Democrats consider themselves liberal, or why Justice Clarence Thomas thinks eminent domain is just a fig leaf for Negro removal, we have to look at what Black people actually thought and did with law. Most of all, if we want to understand why so many Black people put their faith in law at all when the movement came, and I think this is a question that is of vital importance now when Republican leaders are trying to undermine our faith in the very idea of rule of law, we have to know what law meant to their ancestors before the movement. In short, if we want to understand Black people's demands for the rights that America denied them, we have to pay more attention to how they talked about and used the rights that were not denied them, the rights of everyday use. But I think we should go further. We should try to see Black people's political and economic and religious and family commitments as more than episodes in race relations, more than echoes of America's original sin, more than signposts on the road to a more perfect union or facets of a struggle for Black freedom. My basic premise is that Black people's lives are worth studying in themselves. Today, county courthouses are still seats of power. Circuit clerks still have enormous discretion over the civil rights of everyday use. But because of the freedom struggle waged in the 1960s, an African-American researcher like me can consult without special pleading the ledgers and loose papers that for more than a century had embodied civil rights. Yet because of that same freedom struggle, people today don't think of those documents as the stuff of civil rights, much less as the stuff of freedom. And that's one reason why I was able to use these documents. Nobody cares about old court records. So rather than being suppressed or locked away or reverently preserved, the documents that hold these precious glimpses of the past have simply been neglected. Many of them are rotting away because counties don't have money to keep them dry, or they're being destroyed because most states don't consider county court records to be historically valuable unless they're connected to someone famous or to the freedom struggle. But for now, they're still there for anyone who's willing to look. Thank you. I do not know when I started, and so maybe we're all out of time.
No,
No,
we
no,
have
we
time.
have
We have time?
time.
Okay. Uh-oh. Okay, but I can.
Lawrence Friedman.
Well, first of all, I have a comment, but first I want to say that I have rescued boxes after boxes of county court records, which are now owned by the Stanford Law Library, which never wanted them. Your last comments were very welcome. So I loved your talk, but I want to make a point which is in some ways extremely tangential to your main thesis. But I was particularly interested in what you said about the use of the law by African Americans, let's say in Mississippi, during a period in which Mississippi was not a democracy at all. It was a dictatorship run by white people, which actually the majority of the population were deprived of certain rights. And even in Mississippi, which is the extreme case, there was a great deal of use, as you point out, and I think this is a really valuable point, of cases about land, about contracts, about marriage and divorce, and so on. And this reminded me of a body of literature which is quite interesting, which has nothing to do with the US at all. For instance, studies of East Germany or studies of China, Vietnam, in which researchers say there was a dual system. Anything that challenged the political leadership or that looked like rebellion was suppressed. But the ordinary courts were being used by ordinary people for precisely the kind of cases that you mentioned. And so I think that actually what you're talking about gives us a great deal of insight, not only into the lives of African Americans, but into the nature of society in the southern one-party states during the long period from Reconstruction to the Civil Rights Movement, in which they behaved like the autocracies always behaved, except that it was a racial element instead of political versus the unpolitical people. And I think that your research helps us to understand the nature. It's so easy to say white supremacy as if that was a single thing. But your research tells us what it consisted of in a richer way than we're used to. Because, you know, what you started out by saying about the conventional narrative, this is also a conventional narrative about the white South. That it was a kind of monolith of people. There were the whites and then there were the African Americans. But actually, it's a much more complicated and richer picture than that. I think that, you know, what you're doing is really enormously interesting and valuable. The North, I don't know what to say about the North. It's in a way harder to understand. When I used to teach history of American law, we got up to the Civil Rights Movement. I would say to the class, because it was true, although they would laugh, that I'm now old enough to be a primary source. And I described what life was in the city of Chicago in the 40s and 50s. And I think that there's been not much research about what race relations in the North were really like. Because in some ways they're much more subtle and complicated. There were no fountains that said color. People thought that was disgraceful. They thought they do that in the South, that's really primitive, it's terrible. But we knew growing up, for instance, this is a white beach, this is a black beach, this is a white neighborhood. There were like international boundaries. We also knew that black people voted, that they had a certain amount of power in City Hall, but limited. If you went downtown to a department store, the only blacks you saw were sweeping the floor. There were no black bus drivers and so on. So it was a completely segregated city in some ways, but in other ways much more complicated. And I think you know much more about this than I do, that there is not really a rich literature about what that was like. Anyway, I loved your talk. Thank you.
Thank you very much. And I'm going to take that as a comment and say, I agree.
That's good.
The idea of the South, I mean, I'll elaborate by saying the following. I am trying to unpack this idea of a monolithic white South. And I'm doing it That's one of the things I'm doing, and I'm doing it in a way that I think complements political historians who have similarly unpacked the idea of a monolithic white South, right? And thinking of everybody from Eric Foner on, right? Like this is a place of, it's incredibly dynamic. There are different factions, different interest groups. There's a lot of vying for, jockeying for power. And I'm writing about this in sort of the humdrum world of the county courthouse. And so, I mean, one example of the kind of thing, I didn't talk about it in this talk, but gets at what you're saying in both the North and the South, is why are these white lawyers taking on black clients? And they do it again and again. And I think the answer is pretty simple. It's like, it's a job. Like, they're gonna make some money at it. And in that sense, they have a lot in common with the black lawyers too. And so that, in a way, helps, it's another sort of spine on which I can trace this evolving idea of what the term civil rights means. Because white lawyers, even James Eastland, he's perfectly willing to take on black clients precisely because they're not anti-discrimination law. They're civil rights, but they're not that kind of civil rights, so he's happy to do it. So I really appreciate it, and it sort of doubles down my determination to talk with my colleague, Rachel Stern, who's written about uses of law by ordinary citizens in communist China. And it's environmental law, and it's incredibly important work. Thank you.
Annie?
I wanted to ask you about something that I have spent a fair bit of time thinking about in the last several years, and that is Confederate monuments. So the way that we talk about the placement of Confederate monuments on county courthouse lawns is often as the symbolic move to tell black people, you're not welcome here, you will not get justice here, this is not your place, this is not a place for you. And one of the things that I think was revealed in your slideshow was that the number of ordinary kind of legal cases, right, that you're studying is maybe reaching its highest moment at exactly the same moment that we find these Confederate monuments placed across the South. Specifically in the decade, the first decade of the 20th century, is when you see the largest sort of expansion of these monuments. And I guess I'd like to hear sort of your thoughts or reflections on whether or not, in light of what you're telling us, we need to revise the way we think about what it is white actors are trying to do in placing those Confederate monuments in those particular spaces, or how it is we should understand what black people took the placement of those Confederate monuments on courthouse lawns to mean.
That's a really good question. Pointing out that coincidence in time. I have to think about that one. I know how I felt going to those courthouses. They all have monuments out front. I did not like seeing them. I'm pretty light-skinned, so I'm fully aware of my positionality, like going to research in a place like, Holly Springs, Mississippi. But it freaked me out, seeing, this big soldier facing north, or a cannon and stuff. My sense, just sort of reading these records, is that those monuments are definitely sending a message. I'm not sure whether you're asking if there's a causal connection between increasing black court usage and the rise of those monuments. I'm not sure, like in the way that people have drawn a connection between sort of the adoption of the Confederate insignia into Southern state flags at the same time that the 1930s litigation struggle gets going. I'm not sure, I don't know how to answer that question. I think my instinct is to say that there's not necessarily a connection, precisely because, I believe in my thesis, which is that it is not a threat to see black people in the courthouse. The people who are in charge there are perfectly capable of shoring up white supremacy in other realms. But it is a really interesting coincidence.
I mean, more than anything, I guess I'm interested in, so some of this is if this is supposed to be a tactic of intimidation, it's obviously not working on one level. But I think in another level, right? I mean, you're suggesting that a project of white supremacy actually sits, quite tidily, quite neatly alongside these sort of two activities. But I think it does.
That's what I'm saying. Yes. It's not just the monuments; it's the lynching. I mean, lynching reaches its peak.
Right.
1892, 1900. That's around when black land ownership is at its peak. It's not just the courthouse usage. It's certain kinds of black economic achievement. They're rising at the same time as, these horrific acts of white violence, as well as the erection of these, monumental forms of signaling.
Thank you so much for this. I found it very compelling and very moving. I wanted to ask about the examples you drew from the case books and the many cases of key importance to all manner of kinds of law that have been whitewashed, as it were, or have been allowed to pass as white, I think was your
Case
phrase.
books, yeah.
And I would love to hear your thoughts about the relationship between legal history, and I think there's also a really important aspect in your talk about the historians who went there long before us and who did it against much steeper sort of obstacles than we, Baruch Hashem, ever have to deal with. So what then do we do with the relationship between legal history and the work that many of us in this room are doing, and the ways that the way that case books are written and the way that case law is taught, and the particular narrow version of legal history that becomes legal education, in the sense that part of legal education is knowing the history of key cases, but none of the life histories of the individuals whose lives these cases are doing. If that makes sense.
No, I appreciate that question, and I thought about this a lot when I was writing something that's sort of outside the parameters of the book. It's in an article I wrote in Penn Law Review. I thought about, does it matter if we know that, that these people were actually talking about selling to a black person, or that this was a Negro boy? Like, does it actually matter? And I guess one way to think about it is it a material fact? Would it have made a difference to the outcome of the case? And there I think, well, maybe. And in a way, I sort of came to think, well, why wouldn't it? Why is the burden of proof in this direction, that we have to prove that it would have made a difference to the outcome of the case? It's kind of hard to prove counterfactual. But the other dimension that I'm really interested in, it really is the students sitting in the classroom. Like, legal education, it's teaching law students about law, legal principles, legal theories, how to practice law, and you can do it in a variety of ways, and you're always kind of having to pick the casebook authors are picking which facts are material in the sense of what's going to advance the learning of the case. Here, I think including race requires us, or maybe invites us, to open up our vision of what it means to learn the case, right? Like, if you want to learn the rule, then I think it matters that that Ricketts was black, right? In a sense, what I'm saying is, yeah, maybe it's just context. Maybe it sort of enriches our understanding in that way. But in another sense, we might want to think about, like, well, what was Jerome Frank actually doing when he declined to say that Sidney Ricketts was black? And I think what he's doing is he's counting on the fact that everybody in this, everybody in the audience, written and oral, knows that if you're talking about a waiter on the Pennsylvania Railroad, he looks like Uncle Ben. And I say Uncle Ben because they're running ads at that time. It's like he's the cream of wheat guy. he's literally a black man with a white hat on a train with a big smiling face. And I think Jerome Frank is mobilizing that imagery. He's having it both ways, right? It's a black case for certain purposes, and it's a not black case for the purposes of illustrating this universal dispute between the will theory and the objective theory. I think that when we're teaching these cases, it can actually inform, some of the ways that we understand the making of legal theory, if that makes sense. I don't claim to be an expert in this stuff. I'm just a humble farmer, historian, kind of meddling in things I don't know enough about. But that's kind of the way that I've been slowly coming to think about it. Thank you.
I think we are pushing against the clock, unfortunately, so thank you so much.
Thank you.